welcome back, or thank you very much for joining us for the European Law Interviews. This program is sponsored by the Monnet Chair, which is part of the European Commission Education and Training Program, promoting innovating learning programs on matters related to EU studies. We have the great opportunity today to interview Professor Nicolas de Sadeleer. He is a professor in EU and environmental law at Université Saint-Louis Brussels and Université Catholique de Louvain. Good morning, Professor.
Good morning.
Thank you very much for joining us. We will discuss today a second interview on tax law, harmonization and national restrictions. So member states within the EU have the possibility to adopt a wide range of measures. It may be, for example, products regulations or eco-taxes. So the measures can be fiscal or non-fiscal in nature, and they can have an impact on the principle of free movement of goods. So, for example, they can be equivalent to custom duties or have a discriminatory effect. We will discuss all this today. First of all, we will go back to the notion of eco-taxes or eco-taxation, because it's a very important and touchy issue. So, for example, in France, there were several problems with an eco-tax on trucks. And so, Professor, my first question will be, what is an eco-tax?
Well, one won't find any definition neither in treaty law nor in secondary law. Not even in national tax law. So the definition has been so far carved out by economists, and they do define an eco-tax as a fiscal measure characterized by, on the one hand, its environmental objective, and on the other, by its tax base. So the tax base and tax rates do incorporate environmental externalities in the price of the goods or the service. So the idea of ecotaxation is to reflect the environmental performance of the product or the service, but it's also to give an advantage to that product or to that service to the detriment of competitive products and services. So for instance, in the 1997 communication of the European Commission on environmental charges, the European Commission has been stressing that an eco-tax, an environmental tax, does affect the marketing either of the product or the good.
Thank you. In order to be able to understand very well this difficult topic of taxes and environmental taxes, we have to go back to two notions, so negative and positive harmonization. Negative harmonization refers to treaty provisions prohibiting barriers, fiscal or non-fiscal barriers, to free movement of goods. And then we have positive harmonization, which refers to directives and directives provision setting out common standards. Professor, can you please re-explain these two different notions?
Well, I imagine that you did the job perfectly so far, but in a nutshell, there is a negative harmonization of charges and levies in the treaty. So the different provisions, Article 28, 30, or 110 provision that we will later on discuss, do restrict the room of maneuver of the member states in laying down their tax instruments. So as a matter of law, these provisions do apply directly. As a result, companies are allowed to invoke directly these provisions before the national administration or the national courts. So they don't have to wait that these provisions are being fleshed out into proper directives or regulations. Conversely, positive harmonization is adding flesh to the bones of negative harmonization. Positive harmonization is carving out a common playing field in laying down common tax bases or common tax rates across the EU. So positive harmonization must be seen as a complementary approach to negative harmonization.
Thank you very much. So now that we are familiar with harmonization and eco-taxes, I was wondering, is there any harmonization taking place in the field of eco-taxation, or is Article 113 of the TFEU, so the special procedure provision, an obstacle?
Well, Article 113 is a serious obstacle. Article 113 provides for a special legislative procedure, in contrast to the common legislative procedure. The special legislative procedure restricts the decision-making process to the Council of Ministers. The European Parliament gives an opinion, but this is not a binding opinion. So the Council of Ministers is going to decide in its own right on the proposals made by the European Commission without hardly any interference from the European Parliament. In addition to this, within the Council, the Minister adopts the proposal for directive or for regulation by unanimity and not by qualified majority. So it's a tremendous change compared to the former co-decision procedure or the common legislative procedure, you know. And so far, the special legislative procedure in the field of taxation has been a stumbling block for eco-taxes. For instance, the European Commission in 1991 proposed the Council, the ECOFIN Council, to adopt a common integrated CO2 tax scheme. That proposal was rejected in 1991 by the Council. The Commission later on modified its proposal and came with a new proposal in 1995, leaving the possibility to the member states to apply to shelve a CO2 tax. That second proposal was dismissed by the Council. Later on, the European Commission didn't make any effort in the field of eco-tax to bring further proposals. So, in brief, the special legislative procedure is a very serious obstacle, stumbling block for eco-taxation. And amazingly enough, whenever we are dealing with a huge number of harmonized standards with respect to the characteristics of the products, in sharp contrast, there is no clear harmonized projects in the field of eco-taxation, and that's perhaps a huge failure of the EU environmental policy.
Okay, so you just said that there is no harmonization in the field of environmental taxation.
In addition to this, I would like to add that under Article 192, paragraph 2 of the treaty, there is the possibility to harmonize environmental taxes in as much as the unanimity rule is being applied. So both under Article 113 or Article 192, it's impossible for the Council to escape the unanimity rule so far.
Okay, so member states are pretty free to carry out their own environmental taxation policies. And isn't it chaotic then, the legislative framework in the EU?
Firstly, the absence of harmonization entails significant freedom. Member states are sovereign in the field of taxation in as much as they comply with Article 28, 30 or 110. For instance, in the Futura Immobiliare judgment, the Court of Justice underscored that member states were endowed with broad discretion in carving out an environmental taxation in the field of waste management. As a result, the member states are endowed with a great room for maneuver in deciding which products are subject to eco-taxes and at whatever rates they wish. Accordingly, environmental taxation at national level is being pulled in different directions. For instance, 2006 studies highlighted that the eco-taxation share in Denmark ranged above 10% of the global share of taxation, whereas in the same year, the eco-taxation share for Belgium, France, Austria or Spain was lower than 6%. In addition, some member states do emphasize a redistributive approach while enacting eco-taxes, whereas other member states favor an incentive approach, placing emphasis on the needed change of undertakings behavior or consumers' behavior.
Okay, thank you. So you said that there is no harmonization, but then what about this Eurovignet directive?
Well, to some extent, some directives provide for minimal harmonization or allow the member states to adjust their rates or to favor exemptions with a view to favoring goods that are more in accordance to the environmental policy. That being said, one must note the modification brought recently by the Six-Pack to the Stability and Growth Pact of 1997. The Six-Pack introduced an European semester that synchronized the multilateral surveillance not only of the Eurozone member states but of the 28 member states. So the different economic and budgetary programming of the member states are nowadays being controlled by the European Council, the Council of the European Union, as well as the European Commission within a single framework called the European semester. In the course of that semester, the European Commission is taking into consideration a shift from a taxation on labor toward a taxation on natural capital. So, for instance, on the 20 September 2011, the ECOFIN Council has been requiring the Commission to integrate within the European semester a resource efficiency approach to national taxation, which, according to the Council, will pave the way for a successful transition to an eco-efficient economy. So at the end of the day, one could expect some sort of informal harmonization in the field of eco-taxation thanks to the European semester.
Okay, thank you. This brings us to another principle, the polluter pays principle. Eco-taxes are often seen as a good way to implement this principle. Can you please tell us a bit more about the ratio of this principle and its relevance in the field of environmental taxation?
This environmental principle is enshrined in Article 191 of the Treaty on the Functioning of the European Union, and it's being set side by side with the principle of precaution or the principle of prevention. In a nutshell, the use of environmental goods give rise to externalities, to pollution, to nuisance, to environmental risk. These externalities so far are not reflected in the prices of the services or the products. As a result, consumers benefit from a fairly low market price that are not reflecting the true cost, the true environmental damages. To conclude with, according to the principle of the polluter pays, external cost must be internalized into the prices of goods and services, impairing the quality of the environment. So in a nutshell, the polluter pays principle is a rule of cost allocation, taking ground in the theory of the externalities. And as a result, the polluter pays principle can be applied either through a redistributive way, so the principle can help the national authorities fighting environmental pollution to finance themselves thanks to specific charges. But the principle can also be applied with a view to modifying undertakings behavior or consumers' behavior in increasing tax rates of the more hazardous products or the most hazardous services.
Thank you very much, Professor. I have a last very general question. So you introduced positive and negative harmonization, and we know that negative harmonization prevails positive harmonization, so we have to go back to treaty provisions. Environmental taxation may be there to raise revenue or to influence the behavior of consumers or companies. At the end of the day, they may end up protecting domestic products, so they may have the effect of fiscal or non-fiscal barriers to free movement of goods. So we have to highlight the factor for the practitioner, of course, that he has to distinguish the prohibition of charges having equivalent effect to custom duties or discriminatory internal taxation, so mentioned in Articles 34, 35 and 110 of the TFEU, from quantitative restrictions or measures having an equivalent effect on exports and on imports, and those are the measures we discussed in the first series of interviews. So my question is, can these treaty provisions overlap?
Well, indeed, the internal market law is somewhat complex on the account that the treaty on the functioning of the European Union provides for a number of provisions restricting the freedom of member states to lay down appropriate instruments that are likely to restrict free movement of goods, be it at the level of taxation, be it at the level of selling arrangements, or be it at the level of product requirements, as we already discussed. As a matter of principles, these provisions do not overlap. So the practitioner must be aware as to how to select the relevant provisions that's likely to apply to the tax instruments, to the charge, to the levy, to the excise duty, or to the product requirement, or to the selling arrangement. This is indeed a fairly complex exercise, in particular on the account that each provision is either absolute or provides for a different kind of derogation that are subject to restricted interpretation. So the practitioners must really assess, according to the conditions laid down by the Court of Justice, which will be the relevant provision to address.
Thank you very much, Professor. This is the end of the second interview of our second series on European law and the internal market. This was sponsored by the Jean Monnet Chair, which is part of the European Commission Training and Education Program. Today we discussed taxes, harmonization and internal restrictions. We started with a short analysis of the notion of ecotaxation. There is no clear definition, but it's very important. Then we saw that there is no harmonization in the field, even if we have the Euro-Vignette Directive, and even if it might happen one day, and we also discussed the European semester in this line. Then we also saw a very important related principle, the polluter pays principle, and finally we saw that there is no overlap between eco-taxes and quantitative restrictions on imports and exports. So it is very important for the practitioner to find the relevant legal base and to avoid mistakes, because there is no overlap. Then we compared provisions on measures equivalent to quantitative restrictions with the provisions on the prohibition of charges equivalent to custom duties and to discriminatory internal taxation. We would like to highlight the fact that there is no overlap, so those are very totally different concepts and they do not overlap, so the practitioner has to be very careful while choosing the relevant provision. Thank you very much for watching us. We will see you next time for a third interview on tax law, custom duties and CEs. Thank you very much and see you next time.